Good day, Crime Talk aficionados. We have a huge show for you today. First, the Charlotte stabber, Declaros Brown. Well, his half-brother says this guy should never have been out of custody. Two college students report being stalked by Bryan Kohberger. And, well, if you haven't seen his creepy selfies, we'll bring them to you. A juror in the Donna Adelson trial speaks out. The Colorado Supreme Court affirms disbarment of Linda Stanley, the ex-prosecutor in the Barry Morphew case. A cautionary tale from the dating app graveyard. It's like they were saying go to CrimeTalkSearch.com. A Utah woman was sentenced to 1 to 15 years in prison for the death of her husband. The trial begins for a Phoenix chef accused of murdering his family. A woman invoked self-defense and contacted law enforcement following the shooting death of her husband. The Girls Do founder gets 27 years for sex trafficking. 28-year sentence for a charter school employee. Woman sentenced for shooting her husband while she slept. We have a Mother of the Year contestant. This day in legal history. Our legal quote comes from Sandra Day O'Connor and our dumb criminal of the day, which you want to stick around for. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting app. We have a big show for you today. Why? Well, there's a whole lot of killing going on out there. That's for sure. Before we get to the docket, though, let me remind you to go to CrimeTalkSearch.com. Sign up for that background subscription service today. We got a story. Well, somebody probably should have checked out CrimeTalkSearch.com. It literally could have saved their life. Go there, sign up for a background subscription, do a background search, particularly if you're meeting people on dating apps, ladies and gentlemen. Check them out. You're going to find out their social media presence. You're going to find out emails. You're going to find out phone numbers. Google them. They're going to find more information in this report than you could ever get Googling somebody. You'll find out if they're married, divorced, have a criminal history. Are they on a sex offender registry? Everything you want to know before you're going out on a date with somebody, ladies and gentlemen. Go to CrimeTalkSearch.com. You're going to be happy you did. Heck, it could even save your life. All right, so let's go ahead and get to the docket today for Wednesday, September 10th. All right. Like I said, we got a big show, so let's get right into it. So the brother of the Charlotte stabbing suspect, well, he says his brother shouldn't have been out and, well, blames the whole bail process. That's right. The half-brother of Declaros Brown Jr., charged with the fatal stabbing of the Ukrainian refugee Irina Zartuska on a light rail train, has criticized the judicial system that permitted Brown's release on an unsecured bond following a prior arrest, asserting that it contributed to the tragedy. Jeremiah, who shares a father with Brown, informed the press that the incident might have been averted had stricter conditions been imposed by the magistrate judge on Mr. Brown back in January. So Mr. Brown, he's been diagnosed with schizophrenia and experiences homelessness, and he has a history of incarceration and multiple arrests related to violent offenses. And he is accused in the August 22nd attack of this year of Zartuska, who was a refugee here to the United States, came back in 2022 with her family to escape the war in Ukraine. Now, a booking photograph from the Mecklenburg County Sheriff's Office dated September 9th of 2025 depicts Declaros Brown facing charges in the stabbing death of Miss Zartuska. Now, Jeremiah, the half-brother, expressed surprise upon learning of Brown's mental health condition, stating, "I was unaware of his psychological challenges. Individuals with such issues should not be released without oversight," he said. And he emphasized the need for accountability, noting while treatment for his condition is essential, he must face the repercussions of his actions to prevent a reoccurrence. Now, at 19, Jeremiah reported limited interactions with Brown, having met him only briefly, and he described a family pattern of criminal involvement on their father's side, including incarceration for serious offenses. So the surveillance footage from the Charlotte area transit system captures Zartuska's response immediately following the stabbing on the light rail. Now, everybody should watch this, not because people want to see somebody being killed, but it shows the randomness and the brutality of it and the utter shock that Ms. Zartuska was in, where she literally didn't know what happened. And then, well, she basically bled out right there on the train. Well, the family's history includes Declaros Brown Sr., the father with prior arrests for offenses such as breaking and entering, conspiracy, larceny, and unlawful possession of a weapon on the University of North Carolina campus. Jeremiah indicated minimal contact with his father, who resides near the university. Additionally, Stacy Dejan Brown, another half-brother, is serving a sentence of 27 to 36 years in the 2014 homicide of a guy by the name of Robert Hyam, Heym, who was 65. And it was during a robbery in Charlotte. Stacy and an accomplice, Roderick Derrick Crawford, shot the victim and subsequently used the light rail system to flee the scene. Jeremiah recalled viewing news coverage of Stacy's case during his elementary school years, drawing a parallel to the current situation involving DeCarlos Jr. And the Department of Justice has filed first-degree murder charges against Mr. Brown. That's right. Pam Bondi announced that the department intends to pursue the most severe penalty available, ensuring that Brown remains incarcerated for life. But, of course, we noted that there is a little bit of a plot twist there because there's some mental health issues. Will he be competent to stand trial? Will there be some sort of not guilty by reason of insanity type defense? Well, then his sister, a woman by the name of Tracy Brown, shared audio with the Daily Mail of a phone call that she had with Brown 6 days after he was arrested, where he explained that, kind of what was going through his mind when he launched into the bloody attack.
So you said something in your body did what?
Nah, the material, put it like this, the material using my body to stab the lady.
So the 34-year-old who has been diagnosed with schizophrenia can be heard telling his sister he believed the government had planted foreign materials into his brain and that they had been in control of his actions when he pulled the knife on Mrs. Artuska. Now, the recording from the afternoon of August 28th, Brown can be heard telling Tracy, "I hurt my hand stabbing her. I don't even know the lady. I never said not one word to the lady at all. That's scary, ain't it? Why would somebody stab somebody for no reason?" He added he wanted police to investigate the materials which were controlling him while referring to the attacker in the third person. Kind of chilling little audio, but makes you wonder where this case will be proceeding and whether there will be a justice, so to speak, in this particular case. Obviously, we don't prosecute people for crimes if they don't appreciate and understand what's going on. However, it seems to be that he understands the difference between right and wrong, and maybe, well, the doctors will sort it out and find out if he's malingering, faking it, or whether he is truly did not appreciate what was going on. Next on the docket, 2 college students report being stalked by Bryan Kohberger. Weird and creepy, just keeps getting weirder and creepier, doesn't it? So Bryan Kohberger is alleged to have stalked 2 undergraduate students at Washington State University, appearing at their workplaces on a daily basis as detailed by police reports. Now, both individuals reported incidents where they were informed of or heard about someone observing them through windows near their homes. Kaylee, one of the 4 individuals murdered by Kohberger, had previously indicated that a man was following her before her death. And these 2 female college students informed law enforcement that they believed that Bryan Kohberger was pursuing them during his time at Washington State University prior to his involvement in the murders of the 4 University of Idaho students. Now, these students provided statements to police from the Idaho State Police indicating that Kohberger made regular visits to their places of employment. Subsequently, they experienced unexplained disturbances at their residence. One student employed at the university bookstore described Kohberger as appearing accustomed to rejection from women, and she recounted an incident in August or September of 2022 when she was home alone, changing clothes, and heard a knock on her window. She contacted her husband, and after which the individual fled. A similar event occurred later. While at home after beginning her shift, she heard movement on her porch around 7 p.m. Her husband arrived and observed a white vehicle departing the vicinity. Now, Kohberger was known to operate a white Hyundai Elantra. She further noted that Kohberger seemed to possess personal information about her that she had not disclosed to him, including her name and her work schedule. On one occasion, he entered the store and requested her by name, despite her certainty that she had never shared it with him and not wearing a name tag. He also commented on her work hours. Now, the second student, an undergraduate in the criminology department where Kohberger was enrolled, rejected his advances and informed him of her sexual orientation, yet he continued to approach her at work nearly every day. She would advise that she was not his first to encounter issues with him. Now, she described an evening when she was preparing to close the building and noticed Kohberger outside. He made direct eye contact with her through the window, which struck her as a little unusual given the need to look specifically at that location. Fearing interaction, she hid in a restroom after he entered. Later, a neighbor contacted her to report seeing someone near her window and urged her to secure her doors. She subsequently discovered that her residence was in close proximity to Kohberger's, and another classmate of Kohberger's reported sensing someone outside her window, followed by the discovery of footprints in the snow leading to the rear of her apartment. The tracks indicated that the person had retraced their steps. She also mentioned that a peer had heard attempts to open their home during weeks earlier. Now, obviously, Kaylee had expressed concern about being monitored and followed in the period leading up to her murder, along with two roommates and one roommate's boyfriend, obviously on November 13th of 2022. Now, a former roommate from the residence where the incident occurred had told authorities that she feared harm to her friends, attributing it to an observer. She described persistence, unease at the house, which contributed to her reluctance to return. And well, guess what, ladies and gentlemen? If that isn't creepy enough, there's more. That's right. Newly disclosed selfies recovered from Bryan Kohberger's phone depict the convicted murderer posing in his university apartment, capturing various expressions directed at the camera. In one image, the shirtless Kohberger, equipped with wireless earbuds and positioned before a wardrobe containing blue garments, raises a salute while displaying a wound on his knuckle. Another photograph shows him distorting his features into a grimace, exposing his discolored teeth in a broad smile. A third captures Kohberger flexing his muscles, tightening his lips, and narrowing his eyes. Now, these photographs were extracted from Kohberger's phone following his appearance on December 30th, 2022 at his family's residence in Pennsylvania. Specialists in digital forensic analysis analyzed the phone contents, including browsing history and communications, to support the prosecution's case. Jared and Heather Barnhart, experts from the forensic company Celebrite, discussed these images in various conversations that they've given to news outlets. Heather Barnhart, Celebrite's senior director of forensic research, likened the poses to those in the film American Psycho, noting the subject's appearance vanity. She described him appearing topless from his waist up, adopting various stances and facial expressions in front of the mirror, seemingly for personal admiration. Now, her colleague, Jared Barnhart, observed that Kohberger did not distribute these images to others, characterizing the behavior as self-absorbed. He noted instances where Kohberger would remove his shirt, pose capture the moment, and resume his prior activities without further action. Now, the Barnharts labeled the photographs as indicative of narcissism, including unusual perspectives such as rear and side views. Now, obviously, Kohberger, who was enrolled at the Washington State University for a single semester prior to his arrest, and before he was linked to the slayings of the 4 University of Idaho students, and obviously he's serving multiple life sentences in the Idaho Department of Corrections. So, I don't know. Can it get any more weird or creepy? Yeah, I'm sure it can. But as stuff continues to come out, we will bring it to you for sure. I don't know. I can't say I have selfies like that. That would just be weird, wouldn't it? Just to take selfies? I don't know. Maybe it's what the younger generation does. I don't know. Maybe at the time it seemed right. Now it just looks weird and creepy. Just like everything about Bryan Kohberger looks weird and creepy. Next on the docket, a juror in the Donna Adelson speaks out regarding her experience in the Donna Adelson trial. So a juror from the prominent murder for hire case involving Donna Adelson has shared insights on social media shortly after the Florida jury convicted the 75-year-old family head of orchestrating the death of her former son-in-law. So under the TikTok handle Lacey Withda, spelled with a J, common spelling. Anyway, the juror provided an uncommon glimpse into her reasoning during the trial and the jury's discussion, which resulted in a rapid guilty verdict on charges of first-degree murder, conspiracy, and solicitation related to the 2014 killing of the Florida State University law professor Dan Markel. Anyway, she emphasized her impartiality throughout the process, documenting key evidence meticulously and adhering to the judge's directives to consider Donna Adelson innocent unless proven otherwise. And on September 4th, 2025, Donna Adelson was led from the courtroom in restraints following her conviction in the case. Now, in her video, the juror refuted claims of predetermining the verdict prior to deliberations, noting that the group reached a consensus on guilt within about 90 minutes. Serving as the foreperson, she monitored participants' nonverbal cues to identify any uncertainties and directed the jury to review each charge and piece of evidence systematically. She highlighted her commitment to evaluating arguments from both sides, both the state and the defense, thoroughly, and the juror remarked that the panel examined all aspects repeatedly, recognizing the gravity of their responsibility and approaching it with the utmost seriousness. Now, the prosecution's case drew widespread interest, centering on the heated custody battle across state lines that allegedly motivated the crime. Now, Donna's daughter, Wendy Adelson, was embroiled in an acrimonious divorce with her husband, who had secured a judicial order blocking her relocation of their two children some 500 miles away from Tallahassee to South Florida, near the Adelson family residence. Now, prosecutors persuaded the jury that Donna, along with her son Charlie Adelson, devised a scheme to engage assassins to eliminate their brother-in-law and the son-in-law. He was fatally shot in his garage back in July of 2014. The jurors' prompt public disclosure reflects a contemporary trend, obviously enabled by digital platforms granting rare visibility into traditional confidential procedures. Now, normally, jurors are given instructions saying that after their deliberations are done, they can speak with as much specificity or none about the case. And if somebody came and harassed them about their jury service, they should report that to the judge immediately. So this isn't far out, but obviously, people now are always looking for their 15 minutes of fame, so to speak. They get on a jury. Who knows? Maybe they'll write a book as well. Anyway, following the trial that took 9 days, the jury deliberated for slightly more than 3 hours before delivering a guilty verdict on all counts. Now, Donna is the fifth individual convicted in the conspiracy, including her son Charlie, that goes back to 2023, as well as the perpetrators that were involved in it. Now, finally, in her online comments, the juror expressed anticipation of additional family indictments, asserting her conviction that Wendy was fully implicated. I think most people think that Wendy should probably be lawyering up. Obviously, she already has a lawyer, but, start making arrangements for those care of those children. We'll have to wait and see what that means. Obviously, Donna Adelson remains in custody pending her sentencing. Next, the Colorado Supreme Court affirms disbarment of the former Barry Morphew prosecutor. That's right. The Colorado Supreme Court has confirmed the disbarment of Linda Stanley, the former district attorney for the 11th Judicial District, who led the prosecution in the widely followed murder trial involving Barry Morphew, accused of, the death of his wife, Suzanne Morphew. Now we have Barry Morphew 2.0, because now they have a body, different jurisdiction, different prosecutor. Seems like they got their ducks in a row a little better this time. So in a 4-2 decision issued yesterday, the court supported the findings of a disciplinary panel, effectively barring Stanley from practicing law within the state of Colorado. This ruling may also affect her ability to practice in other jurisdictions, as many states have reciprocity, and disbarring one, well, you're disbarred everywhere. Anyway, the action against Stanley arose from public comments she made to the media regarding the Morphew case and a separate matter involving a man charged with the death of an infant, alongside accusations against the child's mother for her role in that particular case. Now, the legal ethical rules generally restrict attorneys from issuing certain statements about active cases that could prejudice the proceedings. The disciplinary body determined that Stanley's remarks played a part in the dismissal of both of those cases. Notably, charges against Barry Morphew were refiled earlier this year based upon newly newly uncovered evidence, i.e. the body. Now, according to the records from the Colorado Office of the Attorney Regulation Council, an arm of the state Supreme Court, Stanley joined the Colorado bar back in 2012. Her current status is marked as disbarred. She's previously held admission to the U.S. District Court for the District of Colorado, but was removed administratively due to unpaid fees, not from any misconduct. In the majority opinion, Justice William Hood stated in part, "We conclude that the presiding disciplinary judge did not err by refusing to disqualify himself from the entirety of Stanley's disciplinary proceedings. We also reverse the board's determination that Stanley violated Rule 5.1b, but we otherwise affirm the presiding disciplinary judge's judgment and affirm the sanction of disbarment." Justice Birkenkotter, Justice Gabriel, and Chief Justice Hart joined in the majority, while Justice Boatwright recused himself from the matter. Dissenting were Justice Carlos Samor and Chief Justice Monica Marquez, who raised concerns about procedural fairness and potential bias in the disciplinary process. Justice Samor noted in part, "We conclude that the presiding disciplinary judge did not err by refusing to disqualify himself from the entirety of Stanley's disciplinary proceedings, but we also reversed the board's determination that Stanley violated Rule 5.1, but we otherwise affirm the judgment and affirm the sanction of disbarment." Steve Jensen, Stanley's legal representative, expressed regret over the outcome in a statement to reporters. He said that we're disappointed in the final result. He said he was trying to have the court just suspend Miss Stanley, not disbar her. He added that Stanley could seek reinstatement after a period of years. Usually it's 3 years, but the Supreme Court decision stands as conclusive for now. She messed that one up. That whole case was botched. I think she just did not have the experience to run an office, to be a DA, and then handle such a high-profile case. She got over her skis, and unfortunately, well, it was her own unraveling. And of course, there's other issues about who should be paying attorney's fees, and the county wants the money reimbursed. It's just a big mess. It's just a big mess. But it just kind of shows you when you're in public office, elected officials, you need to be careful of what you say about cases because it could get really, really ugly. All right, let me give you Exhibit A. All right, a cautionary tale from the dating app graveyard. In the perilous world of online romance, where swipes can lead to sparks of gunfire, a California man serves as a stark reminder to hit search before you hit match. Rockham Powell, a 34-year-old with a panache for turning dates into deadlines, faces charges for 2 murders and 1 attempt at slaying, all courtesy of connections made on a popular dating app. Think of this as your wake-up call before downloading the app. Log into crimetalksearch.com for a quick criminal background peek. Why? Because forewarned is forearmed and far less likely to end up in the forest. Let's rewind to 2021 when Prowl allegedly turned a promising meetup into a permanent checkout. Miguel Angel King thought that he was in for a night of connections. Instead, he got a fatal disconnection via gunshot, followed by a carjacking. Authorities later found King's ride ditched miles from Prowl's pad, with forensic breadcrumbs leading straight back to the suspect. King's bodies discovered weeks later in the Angeles National Forest, proving that not all trails lead to happy endings. Fast forward to 2023, and history repeats for a twist of invisibility. Robert Gutierrez vanished after linking up with Prowl near the latter's home turf. His family sounded the alarm 2 days later, but Gutierrez's remains are still playing hide and seek. When cops nabbed Prowl, they spotted Gutierrez's car cozy in his garage alongside evidence that screamed guilt. If only a pre-date CrimeTalk search had flagged Powell's rap sheet, might have saved a life and a parking spot as well. The plot thickened in February of 2025 with a survivor who dodged the Reaper. A 40-year-old victim met Prowl a few miles out, only to be bound, robbed, and bashed with a baseball bat. And in a plot twist worthy of a thriller, the man escaped, but Prowl revved up the vehicular encore, clipping him and shattering his leg. Miraculously, the guy lived to tell the tale and ultimately pressed charges. Prowl, already on probation for a burglary spree in the posh Beverly Hills and LA area from 2019 to 2021, was collared last week and arraigned on Monday. Prosecutors aren't mincing words. Multiple murder counts loom large. Moral of the macabre story: in the dating game, charm can mask harm. A swift scan of CrimeTalkSearch.com for criminal records, bankruptcies, or red flags could be the difference between I do and I do. This isn't paranoia, it's prudence. There you go, ladies and gentlemen. Exhibit A, why you need to go to CrimeTalkSearch.com. Next on the docket, a Utah woman was sentenced for going to prison for the death of her husband. That's right. Yesterday, a court in Utah imposed a prison sentence of 1 to 15 years for Catherine Restelli for her involvement in the death of her husband, Matthew Restelli, whom she enticed to travel from California under deceptive circumstances to facilitate his killing with the assistance of a couple of relatives. So back in July, Restelli entered guilty pleas to charges of murder and conspiracy to commit murder, classified as a second-degree felony there in Utah. These pleas followed her arrest in connection with the shooting death of her 42-year-old husband the previous year. Now, the judge issued identical sentences of 1 to 15 years for the murder and conspiracy charges, in addition to a term of 5 years to life for felony discharge of a firearm. The sentences for murder and firearm discharge are to be served consecutively, while the conspiracy terms will run concurrently. Now, the judge further mandated that Restelli have no contact with her children, stating, "Your children are victims of your actions. They will remain affected throughout their lives, and they merit the opportunity to develop without your presence." So if you may not recall, Restelli confessed to collaborating with her mother, Tracy Grist, and her brother, Kevin Ellis, to deceive Matthew into traveling to Utah back in July of 2024 by suggesting a desire to reconcile their marriage. She instructed him to enter her mother's residence in the American Fork directly, as the door would be unsecured. Upon entry, Matthew was fatally shot by Ellis and Restelli's brother-in-law. Initially, the family asserted that the incident occurred in self-defense, but investigation findings indicate that a knife discovered in Matthew's hand had been positioned unnaturally post-mortem, suggesting it was deliberately placed there after the shooting. So the couple resided in California and faced, obviously, some marital difficulties, prompting Restelli to relocate to Utah with their children to stay with Grist, the mother-in-law. Anyway, upon discovering Matthew's intention to retrieve the children, Restelli falsely assured him of her willingness to reunite the family. During the probe into Matthew's death back in July of 2024, police confiscated mobile devices, i.e. phones, belonging to Restelli, Grist, and Ellis, revealing that they had monitored Matthew's journey using an AirTag concealed in his vehicle by Restelli. And at the time of the shooting, Restelli was present in the bedroom within the home. As part of the plea agreement, Restelli admitted guilt to the lesser charges of murder and conspiracy, resulting in the dismissal of additional counts. Trials for Ellis and Grist remain pending. A whole lot of killing going on, isn't there, ladies and gentlemen? A lot of husbands and wives and husbands. But wait, there's more. The trial begins for a Phoenix chef accused of killing his family. That's right. The trial started for a man charged with the murder of his estranged wife and 2 children at a Phoenix apartment complex going back to Christmas Day in 2017. That's right. 7 to 8 years later, ladies and gentlemen, we're finally getting a trial. Please meet Anthony Milan Ross, a well-known vegan chef in the Phoenix area, frequently appearing on local television programs. Well, back in January of 2017, he was featured on a morning show there in Scottsdale regarding a big food festival. Less than a year later, however, Ross faced a judge accused of killing his family. Court documents state that witnesses observed Ross fatally shooting his estranged wife, Iris, before returning to his apartment near 16th Street and Highland Avenue, leading to a 6-hour standoff with the Phoenix police. And when police entered the apartment, Ross allegedly fired at officers who returned fire, and, well, he was apprehended, and police discovered the bodies of his 2 children, Nigel, who was 11, and Nora, who was 10 months old. Real nice guy. Anyway, just hours before the incident, Ross posted a video on social media showing him singing a Christmas carol with his son. He faces now 3 counts of first-degree murder and 20 counts of aggravated assault. That would be against the police officers. And the case has now reached trial over 7 years later. Why the delay? Well, obviously, this is a capital case involving 3 deaths with mental health defenses requiring a lot of expert evaluations. Additionally, the shootout with police adds some complexities, making this far from the typical case that would resolve in a few years. Anyway, in opening statements, prosecutors portrayed Ross as a man consumed by his public image whose seemingly successful life unraveled when his wife initiated divorce proceedings 6 months prior to the killings. And defense attorneys countered that Ross was battering depression and that the acts were not premeditated. Anyway, the trial is projected to go into June of 2026. Are you kidding me? Anyway, a conviction could result in the death penalty. Keeping with the theme of a whole lot of killing going on, a woman in Texas kills her husband, but says self-defense. That's right. A woman appropriately invoked self-defense and contacted law enforcement following the shooting death of her husband at a Harris County residence on Tuesday evening. The shooting was reported around 7 p.m. Tuesday at the home in the 600 block of Diantha Street in West Harris County. Well, the Harris County Sheriff's Office indicated that the woman dialed 911 to report that she had shot her husband amid a physical altercation. And by promptly calling emergency services and claiming self-defense, she followed appropriate procedures in such circumstances. How many times have I told you that, right? Fight, self-defense, call police, stay there. Much more reasonable than fleeing the scene and trying to cover it up and then claiming self-defense. It never works. Anyway, the sheriff's office states that the man suffered at least 1 gunshot wound to the upper torso and was pronounced dead at the scene. The man's wife was detained for questioning. Police confirmed that the child was present in the home during the incident but was unharmed. So, we'll see, try to follow that and see how that turns out, if they're going to file charges or not. According to the sheriff's office, the woman informed detectives that an argument with her husband escalated into physical violence, prompting her to fear for her life in self-defense. Her actions in claiming self-defense and immediately notifying the police aligned with recommended protocols for individuals in imminent danger. Anyway, investigation will continue. The cases maybe go to the grand jury to decide whether any charges against the woman are warranted. Sounds like she did everything right. Never, ever harm a woman. I don't know what happened. We don't. There you go. Has a much better chance. Not I'm saying to kill people, but if you're in fear of death or serious bodily injury, call the police. And if it's going to take a while for the police to get there and you have to use deadly force, make sure you call the police and say self-defense. First words out of your mouth, self-defense. Next on the docket, the Girls founder receives a 27-year sentence for sex trafficking. Michael James Pratt, the mastermind behind the sleazy San Diego operation that lured young women with sham modeling gigs, has been handed a 27-year federal prison stint for sex trafficking. Now, the Kiwi-born entrepreneur who once topped the FBI's most wanted charts like a dubious celebrity finally faced the music in a San Diego courtroom on Monday. Pratt copped a guilty plea back in June, admitting to his scheme where he and his accomplices deployed deceit, pressure, and outright force to ensnare hundreds of victims, plenty of them barely out of high school. And the judge, U.S. District Court Judge Janice Sammartino, didn't mince words, slamming him with convictions for sex trafficking via fraud, force, and coercion, plus the conspiracy charge to boot. After dodging justice like a pro for 3 years, fleeing in 2019 amid mounting charges, Pratt was nabbed in Madrid in 2022. His brainchild, the shuttered Girls Do Porn site, had masqueraded as a legitimate enterprise until a 2019 civil suit from 22 brave women blew the lid off. They detailed a nightmare of being boozed up, doped up with weed, herded through unread contracts, and in some cases, trapped in hotel rooms enduring assaults until the cameras stopped rolling. A judge in 2020 delivered a satisfying $12.7 million smackdown against Pratt and his operations. Wiz Matthews, Isaac Wolf, and performer producer Ruben Andre Garcia. Now, Wolf, the site's jack of all trades, handling everything from cash to cameras, pled guilty in 2022 to conspiracy and got a 14-year sentence behind bars. Garcia drew a heftier 20-year term, while the cameraman Theodore Guy, Gye, got off lighter with 4 years after their own guilty pleas. Talk about a cast of characters whose productions ended up in a courtroom finale. No sequel. No sequel is in sight as of just yet. And guess what? District attorney got a 28-year sentence against a former school employee. I wonder what the employee could have done. Anyway, the San Joaquin County District Attorney's Office disclosed that Eric Whiteside, previously employed at the Able Charter School in Stockton, had been sentenced to 28 years in state prison for entering a no contest plea to several charges, including sexual abuse of children and the dissemination of explicit content to minors. So how did all this go down? Well, back in April of 2023 through June of 2023 in the San Joaquin County, Eric Whiteside perpetrated sodomy on a minor victim, referred to as John C. Doe, who was between 14 and 17 years old, and deliberately transmitted explicit materials of those individuals with the aim of stimulating sexual interest. Furthermore, between September of 2006 and December of 2010 in the San Mateo County, Whiteside carried out 3 or more instances of significant sexual activity with another minor identified as Jane K. Doe, who was younger than 14, spanning a duration of not less than 3 months. And during the period of April of 2023 through December of 2023 in San Joaquin County, Whiteside impersonated a young female and distributed explicit materials to 7 other minors. And although no direct physical interactions took place with these victims, the prosecution had urged the court to account for those dropped charges to facilitate financial restitution for the affected individuals and to ensure restraining orders preventing any future interactions. So like I said, Whiteside entered a no contest plea, which is a guilty plea, but he should have to say guilty, you would think, right? Anyway, he pled guilty to ongoing sexual abuse, sodomy involving a minor, as well as a dissemination of explicit content to a minor. The aggregate sentence totals 28 years in state prison. And needless to say, the district attorney's office is quite proud of themselves, as well they probably should be, by getting a pervert out of the schools. Now, we've mentioned it before, ladies and gentlemen, you need to be careful of who is around your children. General rule, like I said, I love my children. I do, but doesn't mean I want to hang out with a bunch of little kids. Okay. And if somebody wants to hang out with a bunch of kids, I'm telling you, you need to check them out. And make sure they're never alone with little kids. And there's no need for them to text the little kids or even have their phone numbers. Everything would have to go through the parents, because otherwise that would just be weird and creepy. Now, wouldn't it? Next in the docket, a woman sentenced for shooting her husband while he slept. That's right. An Oroville, California woman who was 27, named Jessica Ross Nichols, who had previously confessed to fatally shooting her 22-year-old husband, Mateo Lang, as he slept on the floor of their shared apartment in November of 2020. Well, she got a prison sentence of 35 years to life. Now, according to the district attorney, Mike Ramsey, Nichols appeared before the Butte County Superior Court on November 10th for her sentencing hearing. Now, Ramsey noted that on August 7th, Nichols entered a no contest plea to first-degree murder and acknowledged her use of a firearm in the offense. A judge imposed a term of 25 years to life, enhanced by an additional 10 years. At the sentencing proceedings, Ramsey reported that relatives and acquaintances of Mateo Lang portrayed him as a kind and imposing figure with a warm smile and generous spirit. The depiction countered the defense assertion that Lang had subjected Nichols to physical and emotional mistreatment, prompting her to act in self-defense. Anyway, the attorney presented evidence that that undermined the defendant's allegations of battered women syndrome, and the district attorney indicated that Noel highlighted text messages and self-recorded videos from Nichols demonstrating her role as the aggressor in the relationship. In particular, communications from the months leading up to the incident in which Nichols described hurling objects at her husband, damaging his device and apparel, and confessing to an earlier attempt to poison his pillow using a cleaning agent. The prosecutor further stated that Knoll outlined the forensic findings from the court, which conclusively showed that the victim was reclining on his back and asleep during the shooting. Prosecutors detailed the physical evidence gathered at the location and an audio capturing the event. Additionally, the prosecutor displayed a segment from the couple's home surveillance footage depicting Lang engaging playfully with the 18-month-old son the previous day, thereby challenging Nichols' accusation that he was abusive toward her and neglectful towards the child. Should have picked up the phone and said self-defense. Just kidding. Next on the docket, another Mother of the Year contestant. A 23-year-old woman from Kentucky, identified as Morgan Chapman, has been charged with 2 counts of child endangerment following an incident in which she allegedly abandoned her kids, ages 2 and 4, to go smoke some marijuana. Police from the Pikesville Police Department arrived at the apartment about 9 p.m. in response to a reported domestic disturbance. Upon arrival, the officers were greeted at the door by 2 young children. A subsequent search of the residence confirmed that, there were no adults there. Inquiries with nearby residents revealed uncertainty regarding the mother's whereabouts. One neighbor residing across the hall reported that Chapman had requested her to supervise the children at approximately 5 p.m., which was about 4 hours prior, so that she could leave to go smoke, a phrase commonly associated with marijuana use, as noted in the police report. Anyway, during the ongoing investigation, Chapman returned to the scene of the crime, and the officers observed signs of intoxication, including the odor of alcohol on her breath, bloodshot, watery eyes, and slurred speech. She claimed to have been absent only briefly, visiting a neighbor's apartment downstairs. Needless to say, Chapman was subsequently arrested and transported to the Pike County Detention Center, from which she has been released on bond. She appeared smiling in her booking photograph. Take a look at that booking photo. That says, I am a good mother and I did nothing wrong whatsoever. Or maybe she just doesn't appreciate the seriousness of the situation. Let me know. Anyway, the children were escorted to the police station for their own safety. And guess what? They're going to be having some visits from social services to decide where those children are going to reside. Next on the docket, this day in legal history. On September 10th, 1897, Pennsylvania police killed 19 miners during a strike. That's right. The Luzerne County sheriffs and the deputies opened fire on a group of 400 striking miners in the town of Latimer, Pennsylvania. Around 19 strikers were killed and 39 were injured as a result. A Wilkes-Barre, Pennsylvania jury later acquitted the county sheriff, James Martin, and his deputies after claiming that the strikers advanced upon the police. Self-defense, ladies and gentlemen. See, that's what you get for striking. No, just kidding. But a jury decided, so that had to be it, right? I'm sure there was no influence in whatsoever. I'm sure all the jurors worked there, and if they wanted to keep their jobs, had to find for the sheriff. Who knows? Next on the docket, the legal quote of the day comes from our former justice on the Supreme Court, Sandra Day O'Connor. The proper role of the judiciary is one of interpreting and applying the law, not making it. That's right. Judges don't make law, they interpret it. They apply the law to the facts. If they want to make law, guess what? They should go run for the state legislature, run to be a member of Congress, right? Become a congressman, become a senator. But you don't get to be a political activist judge on the bench. You get to simply apply the law, even when you don't like it. That's what judges are supposed to do. Next on the docket, our dumb criminal of the day. A caped crusader in comfy attire. That's right, a Florida pajama-clad vigilante foils a midnight marauder. In a twist straight out of a comic book caper, a Florida resident turned nocturnal knight when his Batman-themed sleepwear became the uniform for an impromptu crime-fighting spree. Kyle Myvet embodying the spirit of Gotham's guardian without the utility belt, single-handedly subdued a sneaky intruder and held him until police arrived. According to the Cape Coral Police Department, the drama unfolded about 2 a.m. on a quiet evening in southeast Cape Coral. Now, my vet, cozily ensconced in his dark night onesie, was roused from a slumber by a ping from a home security system alerting him to a truck tampering trespasser. Not one to let villains roam free, he dashed outside, still in his heroic loungewear, and spotted the culprit rifling through his car. Undeterred, my vet pursued the pilferer, only to discover him next in the neighbor's garage, helping himself to a little more loot. With the prowess of a pajama-powdered protector, my vet pinned the perpetrator until the police arrived, finding the scene already under citizens' control. A tip of the cowl to the quick-witted neighbor in the Batman jammies for bagging another burglar, the department quipped in their report. The apprehendee, anti-hero, 20-year-old Justin Schimple, a familiar face to local law enforcement, allegedly swiped an assortment of goodies from both vehicles, pricey Ray-Ban shades valued about $300 a piece, a lady's wristlet, and over $500 in gift cards. He tried spinning a yarn about an accomplice, but his story shifted like shadows in the night, and a thorough search turned up no sidekick. Schimple, now facing charges including 2 counts of vehicle burglary, a pair of minor thefts under $750, and one for intruding into an occupied home. His initial court date was set for September 29th, with no word yet on legal representation. In a world where capes are optional, my vet proves that sometimes all it takes to thwart thievery is a dash of daring and a flair for fictional fashion. Anyway, Mr. Vayet, you are not our dumb criminal. You are our hero for the day. And Mr. Simple, guess what? You are a dumb criminal of the day. And the fact that everybody's going to know that you got caught by a guy wearing a onesie in his Batman pajamas, well, you're just forever going to be known as dumb. Dumb, Mr. Simple. Congratulations, you made it. All right, ladies and gentlemen, I know it was a big show, but heck, there was a lot of killing going on last night, so we wanted to bring it all to you. So always remember, never forget, guess what? The Constitution matters.